Hi guys, it's Kathy. I hope you're doing well. Tuesday. We made it to Tuesday. Oh gosh. Okay. I'm muted. It's fine. We're still in Judge Boyd, and we didn't clean up after ourselves yesterday. So I said we would figure it out today, what's going on with this guy, and then now we have to. So I don't know what I think. Okay, so we were just waiting for a while yesterday, where we left off. They had sidebar. We were waiting for a while, and I forwarded it to here. And then I think he might be done. He might not be done. We'll see.
Has everything been redacted?
Yes.
Let's bring the jurors in. All right, you can go ahead and do that, but line the jurors up.
And should I reoffer it, or is it just that, would they come back in and we'll just say it's admitted?
Oh, no, you can, because they don't know what was on 138, you can just offer in 138. And then if you have a 138 that you want to go up with the record that you're offering for your proffer.
I did that as 138.
Okay.
138.
Okay.
If that's fine.
Yes.
She's like, oh, what a cute little lawyer. Okay, I remember now. This guy is not the expert. He's the not expert on anything.
All right, for the jury.
A link to what?
All right, everyone, please be seated. And Vince is still your witness.
Thank you, Your Honor. This time, defense offers defendants exhibit 138 in evidence.
All right, and state your previous objections are noted.
Yes, Judge.
All right, states exhibit 138 will be admitted. I'm sorry, defense exhibits 138 will be admitted.
Okay, may I publish to the
Yes.
jury, Judge?
There is sound. We're just waiting for the jury.
As the church, right?
Yes.
I knew it. I knew it. As soon as I hit fast forward, I missed some. You guys didn't hear them talking a minute ago? Yeah, there was sound. We're just waiting for the jury. Didn't you hear Judge Boyd say get the jury or bring the jury? They're coming any second now.
All right, Mr. Otero.
There we go.
You took that video?
Yes, it is.
Okay, with the GoPro,
That is correct.
and that was on the Chevy Traverse.
That is correct.
And now at the beginning of the video, we see you drive around the parking lot a little bit.
Correct. I was basically just turning the vehicle around so I could exit the property.
Okay, does that part of the video get us a little bit, give us a little bit better perspective on the nature of the parking?
Shows the size of the parking lot.
Okay. And so the next thing you do on that video is you actually turn right onto O'Connor Road out of the church parking lot, correct?
Correct.
Which means you'll be going south, right?
Yes.
And then you find a place to basically do a U-turn, correct?
Yes. Making an improper U-turn in the street.
And so then you turn back left onto O'Connor so you can be going north, correct?
That's correct.
And then you make a left into the CT Calvary Temple Assembly of God Church, right?
Yes.
And then you accelerate and go through the same route that we see the white SUV going in that church surveillance video. Is that more or less fair to say?
Yes, that's correct.
Okay. And then you pass it up and you go through that little artery that's in the back of the church back onto Bucharest.
That's correct.
And now, do you know what an event data recorder is?
I do.
Okay. Can you explain to the jury what that is?
An event data recorder is a component of a vehicle's computer system, which is meant to record data in the event of a crash or an impact or any other anomaly or event that the recorder deems necessary or deems prudent to capture information. Sorry.
Okay. What kind of information is captured on an event data recorder?
If there's any impacts to the vehicle or any damage structure to the vehicle, it will record where that was located, which sensors were triggered. It will record any anomalies in acceleration and braking. And in some cases, it will even record the GPS coordinates of the vehicle in motion.
Okay. So in some circumstances, it would record the GPS coordinates and
Depending on the make and model and manufacturer, yes.
okay. And now, and so that data can be extracted from vehicles, is that correct?
That is correct.
Okay. So how is that extracted from vehicles?
It requires a specific tool that you plug into the onboard port, and usually below the vehicle's dash, and then use that tool to access and retrieve that information.
Okay. Did you have a device that you attempted to extract the vehicle's event data recorder information on?
Yes, it is.
Okay. What kind of device is that?
It's the manufacturer is Bosch CDR, that's crash data retrieval tool, and attempted to use that to retrieve the data from the vehicle.
Okay. Were you able to?
No, sir.
Why not?
The first time we attempted to extract the data, we needed the keys of the vehicle to put the vehicle into the accessory mode prior to actually turning over on the ignition, so that we could get the computer to fire up so we could connect to it.
Okay. Did the detective or the police have the key to that vehicle when we went the first time?
No, there was no vehicle. There was no key to the vehicle.
Okay. And then were we able to obtain a spare key?
We did obtain a spare key.
Okay. And then did we try again?
We did try again.
Okay. What were the results of that second attempt?
We were not able to get the vehicle to recognize the key, and the car battery had been dead for an undetermined amount of time. And with the jump, once we jumped the vehicle, the time frame in which the car had been dead had caused the pairing, I guess, for lack of a better term, of the key to the vehicle to not exist anymore.
Okay.
So they weren't able to get the key fob to respond to the vehicle.
Essentially, it was deprogrammed from the vehicle and wouldn't recognize it.
That's correct.
And there was no way to like insert a key anywhere, was there?
No, it was just a push to start vehicle. The fob just is within proximity of the steering column.
Okay. So there was no like physical metal key that could be inserted anywhere.
That's right.
Okay, so that did we have to
He's
rely
trying.
on that sensor to connect
trying
before
hard.
we could try to put it in the state that it needed to be before you could get that data?
That's correct.
Okay. And can you describe the state of that white Nissan Rogue when we were able to view it at the pound?
The interior of the vehicle was completely covered in debris, dirt, mud, dust. The windows were down on the vehicle, and it was undetermined how long they had been like that, but based upon the appearance of the interior of the vehicle, it appeared that it had been quite some time that the vehicle was exposed to the elements.
Okay, so the windows had been down for quite some time? Or did,
Presumably judging by the debris and by the state of the interior of the vehicle. Yes, that's correct.
all right, I'll pass the witness.
Mayor, you want,
Yes.
thank you. Is it Mr. Arturo or is it Investigator Arturo?
Either or.
Okay. I'm Jason Garahan. I'm a prosecutor, one of the prosecutors in this case. Since you were just talking about the EDR, the event data recorder, are you trained in extracting that from vehicles?
There's not particularly a training required to have access to the vehicle, just a license provided by the company.
Well, I mean,
You pay for a software subscription.
so you pay for a software subscription, and do you have a certain device, or is it just from your computer you hook up to the car?
It's a standalone device
Right.
that plugs into the board.
And so, and is that something that, are you aware of, that if the battery's connected, that, are you saying that if the battery's disconnected, it's not going to keep that information? Or are you aware of it?
I'm not aware of that. I just know that if the vehicle does have power and you are able to get the vehicle to power out prior to the ignition turning, that information is accessible to the court.
Did you check to see if the battery was connected to this vehicle?
I guess we did.
Was the battery connected?
The battery was connected to the vehicle.
So are you aware that if the battery's connected, the EDR would continually record and ends up recording over previous events? Are you aware of that?
No, sir.
Okay. So going back, you were hired by the defense, is that correct?
Yes, sir. That's correct.
And when you started investigating this case, was it in 2025?
I believe it started in 2024.
2024. So to be fair, it's sometime after the event that happened on May 22nd, 2022.
Yes, sir. That's right.
So it's roughly 2 years, give or take. We'll do a guesstimate, right, of about 2024, sometime in that year.
Yes, sir. That's correct.
Okay, so roughly 2 years later. And you said you'd had some previous experiences as, you never were a VCSO deputy, but you were reserve, is that right?
That's right.
And then you were not a deputy at Elmendorf, but you were reserve.
Yes, sir. That's correct.
And is that means you're called in when it's needed, is that right?
That is correct.
Okay. And then you said you worked for a private firm, and that private firm, was that private firm Cornerstone Church?
Yes, it was.
Okay. And you said you've been affiliated with this church your whole life.
Just about.
Just about. Well, okay. And so, well, if you're affiliated with that church, is there a reason that you left?
Why I left the church?
Yeah, well, not the church, but your job there.
As a security officer,
Yes, sir. Because you were a supervisor at some point, right?
at some points.
And then you were not a supervisor any longer at one point. Is that correct?
That's correct.
And then after you were, in a sense, demoted, then you left that location. Is that right?
I chose to pursue a different career point at that
Okay.
time, but that's correct.
But to be fair, that's 2018, and that's when you just started becoming a private investigator. Is that right?
That is correct.
And you had to get licensed for that in 2018.
Yes, sir.
Okay. And so, in particular to this case, you've worked on many cases, you've stated before. Now, you were hired by the defense in 2024, and then you reviewed some of the evidence associated with this case. Is that fair to say?
Yes,
And I think that some of the stuff you reviewed is that you said you reviewed that church video,
yes, sir.
okay, and you looked at Officer Jaime's statement,
That is correct.
and that you actually know Officer Jaime's, don't you?
I did.
You actually worked with him at Cornerstone, didn't you?
I did.
And you actually supervised him at one point there, right?
Yes.
Okay. And then he was there, then at one point he left because he was an SAPD officer that, in a sense, worked a side job for the church. Is that right?
At the time that I left the church, he was still a full-time employee of the church.
Okay.
His departure from Cornerstone happened after mine.
Okay.
Judge, I'm going to object to the relevance of this line of questioning.
Relevancy?
Well, Your Honor, I mean, the investigator that knows the officer, I think that's pretty relevant that he actually knows the victim in the case.
All right, that'll be sustained. I'm sorry, that will be overruled.
Thank you, Judge. You reviewed his statement. You reviewed the dash cam of the patrol vehicle, and you looked at the white Nissan that you testified to earlier. You looked at other reports associated with the case. Is that right?
That is correct.
I'm assuming you probably looked at photographs.
Yes, sir.
And well, you did an investigation in the sense of just perusing like anybody else could go through the material. Is that right?
That's correct.
Okay. And then defense, I guess, in a sense, asked you to do what you did with the video and your own photographs.
Yes, sir.
And I think the word that was used,
How did you
staging
know?
vehicles in this parking lot. Is that right?
Yes, sir.
Why did you do it during the daylight?
Just to give a more, a brighter, more vivid display of what that scene would look like under more optimal, I guess, viewing conditions.
I guess to be fair, I mean, you saw the church video and you saw the photos from that night and you knew it happened at 2 a.m. in the morning. I mean, why didn't you do it at nighttime? I mean, that would show a more fair and accurate picture of what is actually happening that night. Is that right? Is that fair to say?
Yes, it is.
Okay. But you just chose to do it during the daylight.
There was some footage and some pictures that were taken at night. And then there were also pictures that were taken during the daytime.
But everything that came in right now by defense it's all from the daylight and the videos from the daylight. Is that right?
That's correct.
Okay. And let me ask you this, you know, the staging of these vehicles, and again, I think it was even used during your direct testimony that you're guessing at where those cars are supposed to be, right?
Where I placed the vehicles was based upon image provided within the discovery.
And tell the jury what those images are then.
The footage from the dash cam of the SAPD vehicle, the surveillance footage, and the surveillance footage captured by the church.
Okay, so again, you're guessing where you're putting those, staging these vehicles in the parking lot. Is that accurate to say?
Yes, that is.
I mean, because you can't tell that the jury right now that F-150 is exactly where that patrol vehicle was, because you really don't know where that patrol vehicle was, do you?
The exact specifics, no, sir.
Right. And so that F-150 could be further back.
It is possible, but it's not impossible.
Because you're judging it on that tree, right?
That is correct, and also from the fact that in the surveillance footage, you don't see the front end of the vehicle. So that gives us a point of knowing that the police vehicle was beyond that point. And then using the tree as well as also positioning of the light poles from the perspective of the dash cam to the perspective of where the pictures were taken to determine a rough estimate of where the vehicle was located.
A rough estimate is a guess. Is that
Yes.
okay? And so how many measurements did you take that were accurate? Like, did you use the SAPD sketch that they made in this case?
No, sir.
Where they had all the shell casings measured out from a very specific location, the A axis and B axis? Did you use that sketch to recreate the scene?
No, sir.
Why is that?
The metrics that we use to recreate or to attempt to recreate as close as accurately as we could, the positioning of the vehicles was based on the majority of just the surveillance footage and the dash cam footage of the vehicle.
And you also, these photos and this video is all from March of 2025.
I believe so, yes, sir.
Do you believe so, or is that accurate to say?
It's-
Okay, thank you. Are you a trained crime scene recreator?
No, sir.
And there are certain people that are trained for that, right?
Yes, sir.
That can recreate a crime scene, right?
That's right.
And they're trained to do that, and you're not.
Yes, sir.
Okay, thank you. We'll pass witness, Your Honor.
All right, Mr. Otero, I know that there was some discussion of shell casings, correct?
That is correct.
Are shell casings always an accurate predictor of where a shot was fired from? The
Yeah.
position where the gunshot was fired.
I'm just going to object to one, this individual is not qualified as any type of expert in that field.
All right, no foundation has been laid. The objection will be sustained.
May I approach the witness?
Yes.
And counsel asked if you took any photos of that, is that correct?
That is so.
Okay. Now, defendant's exhibit 139, you recognize this photo.
I did.
Did you take this photo?
I did.
Okay. And now what are we seeing in this photo?
This is a photo taken from O'Connor Road, just at the entrance of the church parking lot.
Okay.
The left turn into the church parking lot.
And is there a vehicle that is placed at the top of that hill as well?
Yes, there is.
Okay. What type of a vehicle was this? Was this also the same Ford F-150 or was this a different vehicle?
This is a different vehicle.
Okay, what kind of a vehicle was it?
In this picture, the vehicle that is staged at the top of the hill is the Chevy Traverse.
Okay, and what vehicle are you driving then?
I believe in this picture, I'm driving a 2011 Mercury Grand Marquis.
Okay, and does it appear that the lights at the church are on in this picture?
Yes, they are.
Is this an accurate picture that you took?
Yes, it is.
Okay, at this point, I would tender defendant's exhibit 139 of the statement offered evidence.
No objection, Your Honor.
All right. Defense's 139 is admitted without objection.
And now you actually took a video at night as well, is that correct?
I believe so, yes, sir.
Okay, and that was on a different date from when that photo was taken, correct?
That is correct.
Okay, and when you took the video, the lights at the church were all out, is that correct?
That is correct.
Okay, and so we determined that it wasn't the substantially similar conditions to when the lights were on, is that
Yeah.
okay?
I'm just going to object to leading.
Sustained.
Okay, were the conditions, based on what you reviewed, similar to those at the time of the incident?
No, they're not.
Why is that?
When we took the video of the church parking lot, the lights in the parking lot were off instead of being on.
Okay, and can you describe the lighting on O'Connor Road when you're approaching the church at night?
Sure. That particular section of O'Connor Road is very dark. There's no lighting on the leave it in the lighting on the right side of the street, and the left side, it's just provided by some utility lights and then lights from each property along O'Connor as you drive past.
Okay, I'll pass the witness.
Any
Hey,
questions?
Just briefly, Your Honor, and state, defense exhibit number 139, you can see a vehicle at the top of that hill. That's reversed,
139, should I just look at it?
Mhm.
Yes, sir.
and that's at nighttime,
That is at any time.
and relatively similar, the lights are on in the parking lot. The lights are on in that parking lot?
Yes, they are.
Okay, no further questions, Your Honor.
And in defendant's exhibit 139, you're taking a picture and you're conscious of the car at the top of the hill, correct?
That is correct.
You're trying to get that vehicle in the picture.
That's correct.
Okay, so your conscious objective is to make sure that that vehicle's in there and you're aware of that vehicle from before when you're taking that picture.
Yes, it is.
All right, I'll pass witness.
Any further questions?
No questions, Your Honor.
Is this witness excused?
By the state, Your Honor.
Defense as well, Judge.
All right, you may step down. If you'll make sure you leave the microphone there, please. All right, thank you.
Thank you.
Defense, call your next witness.
Defense rests.
All right, state, any rebuttal?
We close, Your Honor.
Defense, do you close?
Defense rests and close.
All right, ladies and gentlemen, there's going to be closing arguments from both sides tomorrow at 9 a.m. The jury room is going to have the same number of jurors that were called up previously. So you'll need to probably get here by 8:30 to be ensured a parking space. And
I wish we could have heard more from her. I wish she would have did more. I want to see her more often.
Jesus Zamaripa.
She's just doing roll call.
Thank you. And prepared by the presiding juror and submitted to the court through the deputy. Respectfully submitted Judge Stephanie Boyd, 187 District.
I don't know.
Was
We're
never
not
collected as evidence.
okay.
That I
Closing
that
arguments.
the firearm was not parallel.
Public servants. So that element, I'll be speaking to you briefly, and then
Oh, she's not even
defense counsels
talking.
will have an opportunity to speak with you about the
Darn
case
it.
and their views on it. And then also Megan Galloway will be the summation of the closing arguments for this case. And then you will receive the charge, go back to the deliberation rooms and begin deliberating at that point. Remember this, that as the judge said, in this charge is the stated law that you have to follow, that you took that oath. You'll take this charge back to the back. You'll have that copy. You'll have an opportunity to look at it, review it. So don't feel like you had to memorize everything that the judge just said, because it's a lot of stuff in there. I'm going to go over the charge with you. The definitions and the law that abides by this case is in here. What I'm going to go through is talk about one on paragraph 5 and page 5. It talks about voluntary intoxication. There's been a lot of talk about intoxication of this individual. He's already stated he was highly intoxicated by alcohol and marijuana, that he drank at work, he drank after work, he drank at the bar, he drank at Harold's, and he smoked marijuana the whole time. All voluntary. He admitted that on the stand. He cannot use that as a crutch. He cannot use that as a defense.
Judge, I'm going to object to being an improper argument and a misstatement of the law. That instruction is just saying it's not an affirmative defense, meaning that the jury considers that only if they believe all elements have been proven beyond a reasonable doubt. And we've never made that argument in this case, Judge.
All right, objection is overruled. You may proceed.
Thank you, Judge. He cannot use that as a defense.
I'll
Now,
object again, Judge.
Overruled.
moving through the charge, it'll have count 1, which speaks of, and count 1 and count 2 are exactly the same except for the victim, okay? Jaimez and Acuna. Those individuals are police officers. Now, the elements of these cases, you heard Darren Bordier, the date, the county, the defendant. Those are without question are proven. I mean, the defendant got on the stand and admitted that he's the person. Also, another thing that's not even in question is a deadly weapon, the firearm. He admits that it's that he shot that deadly weapon. So none of that is in question. That is not in question at all. What defense counsel most likely will argue is one about whether police officers that he knew was a public servant and a police officer, that patrol car in particular, because those two officers were in that patrol car, got all those decals in this dark parking lot that is obviously lit up. And through their own photograph that they took at night, you can see the vehicle of the investigator, the private investigator that they hired. You can see the reflection of that car in that picture without any decals, without any reflectors on it. So keep that in mind, that the fact is that this individual knew that was a police vehicle, drove down there and shot at these individuals, or at least in the direction of those officers. You heard the testimony of each of those officers that they saw the flashes of that muzzle coming, shooting towards them. You have to just believe them. Believe him. Just believe two officers that are sober, that are patrolling our streets. Just believe them over 10. Now, that's count 1 and count 2. That's aggravated assault on a public servant. Now, count 3 has 2 paragraphs. You have 2 choices. One was with the vehicle, where you knowingly discharge a firearm in or at or in the direction of a vehicle. Notice that this says the vehicle, that he's reckless of whether that vehicle was occupied. Notice also in this count, there's nothing mentioning of any person for that matter, except for the occupants of that vehicle. But also on top of that, it doesn't mention anything about police officers or public servants. So that element is not in count 3, that these individuals were police officers, or that he knew that these individuals were police officers. Just that he shot in, at or in the direction of that vehicle. Keep that in mind. And he's reckless of whether it was occupied. That's paragraph A of count 3. Count 3, paragraph B is shooting at or in the direction of 2 individuals, Jaime's and Acuna, or Acuna, either one, or both of them. Again, one of the elements that's not in that part of the counts, in that count, is that these individuals were public servants or that they were police officers. So that element is not in count 3 at all. Our state's position is that all these counts have been met. No doubt that every element has been proven beyond a reasonable doubt. If you believe the officers. If you don't believe the officers, come back not guilty. If you think they're lying, come back here and say not guilty. We can accept that. That's fine. Because that states that you believe this individual over here. A self-admitted liar. A self-admitted individual that stated, I was trying to talk my way out of it. He was trying to talk his way out of it because at the time that he was speaking to the detective, he didn't know the amount of evidence that they had against him. In fact, the detective didn't even know the amount of evidence that he had against him. They had the vehicle. They had later on, they had ballistics. Shell casings from that car matched the shell casings at the scene that matched the gun that is found where? In this individual's possession, which he says, again, lying, I never shot that weapon, ever. You heard that testimony, self-serving. You heard all these lies over and over. And then you heard him on the stand yesterday, right up here, when he stated, after reviewing all the videos, the reports, then, and only then, did he come up with a better story.
Objection, facts not in evidence, Judge. That's not what he testified to.
All right, ladies and gentlemen, you remember the evidence as it was presented to you?
May I proceed, John?
Yes.
You heard what he said on the stand. All of a sudden, hey, ballistics. We got the DNA. Matches his. From the gear shift and the door handle. We got a fingerprint on the rearview mirror. The car is in his father's parking spot or his driveway, perfectly parked. We have Harold's statement that doesn't really mesh well with his statement that he gave. Got Tatiana, his girlfriend at the time, now his wife, her statement. She also states, and he states that he makes some stupid decisions when he's drunk. You have all this evidence put together, text messages, data from the cell phone, pointing at him, directing it at him. Now, 3 years later, he comes in and testifies and says, oh, I was lying because I was in a mentally bad place. My coworkers were after me. My dad was being mean to me. My girlfriend, my wife, my mother of my child was being mean to me. Everybody's mean to me, but I carry a gun right here, go to work, drink to my fill where I'm highly intoxicated. I can't remember if I had my eyeglasses that I have to see, and I'm driving around, not hitting anything except for, well, a curb after he's shot at because he shot at police officers.
12 minutes remaining.
So when it comes down to it, ladies and gentlemen, he's Monday morning quarterbacking this. He knows that we had a mountain of evidence against him. And so he wants to be like, okay, wait. I follow this other one.
Did anybody hear a mountain of evidence during this trial? Did this trial even tell us what happened? Did anybody in this trial say this is what happened? I know there were people on the stand and I know they were talking. I remember we've been here for 9 days. I know there were. I'm still waiting for someone to tell me like sort of what Tyler said it a little bit. He reached his arm over and he shot the gun, but nobody told us the full picture of, no one said that car, you there's no way for you to see that car. No one said how close the bullets actually got to the police car. You know what I mean? They just heard bullets, but they didn't say, it hit the ground right beside me. Or did anybody give us a mountain of evidence of what was going on in this trial at all?
Story. Make this one up. And I know they have all this evidence. I'll just say I did it, but I didn't mean to do it. I didn't know those were officers. I didn't know that car was there. I didn't know they were police officers. Then it makes a little bit more sense. It's like his story fits after he sees all the evidence, after he has the opportunity to see it all. The story changed from back when he visited to the detective to now. It changed. Lots. He's trying to talk his way out of it. And this phase of the trial is not about his freedom. It's about justice. The freedoms aspect comes in the second phase of this trial, if there's a guilty. That's when you determine if he goes to prison or if he has probation. That's that phase. That's not this phase. This phase is determine justice for our community, justice to not have some individual high on marijuana, high on and alcohol, driving around our streets, taking pot shots at officers, a plea for law enforcement. Don't believe him. Believe the officers. The evidence shows that. Thank you, ladies and gentlemen. I'll reserve time for my co-counsel.
Right, defense.
Please, the court state.
You can wait on that. He's gonna go first. Thank you.
Morning. This case comes down to perspective. And only when you put them all together and you begin to have a clear picture of the series of bizarre events that took place. Now, when you look at the facts available to Officers Jaime and Acuna, it's easy to understand why they thought shots were fired at them at the time that Tyler fired the shots out of his window. Having just come from an aggravated assault case, parked in a parking lot by themselves, a vehicle matching the description of a suspect in that prior ag assault case comes rolling up on them in the middle of the night. During those fleeting seconds that Officer Jaimez had to make a decision and process the information during those fleeting seconds through that lens, it's understandable that in those moments, Officer Jaime may not have noticed every detail, but it's important to look at the details he does remember with the facts that we have now. From his view, he testified he couldn't see the muzzle, and it looked like it was aimed more towards Roland's side of the vehicle, Officer Acuna. Now, this would suggest that the firearm was not parallel with the vehicle, which from the testimony that we heard from Detective Tudor would have been required to fire directly at the patrol vehicle. Now, Officer Jaime has also testified that when he saw the shots fired, he attempted to draw across his lap and shoot through the windshield. And he compared the two vehicles to jousting. We heard from Detective Tudor that of the possible ways that Tyler could have tried to fire a shot at the patrol vehicle, one would have to either lean out of the window and cock the wrist or shoot through the windshield. Now, the photos of the Nissan Rogue, there are no bullet holes in that windshield. And from Officer Jaimez and Acuna's testimony, they did not see anyone leaning out of the vehicle. Only not even the muzzle of the firearm itself. The state took time to point out the muzzle flashes in the church video, State's Exhibit 111, and the last one in particular at 02:01 a.m. But it's important to note that would have been the fourth gunshot fired. The first was Tyler, the first after Tyler's only three. Detective Tudor testified the first shot took place at 02:01:59, followed immediately by two more. Therefore, it would have been Officer Jaimez's gun firing when the vehicles were parallel, not Tyler's.
3 minutes have expired.
At this closest point. The photos you've seen of the patrol vehicle, referred affectionately by Officer Jaimez as black and whites, demonstrate the front of the vehicle is all black and no white, and contains the smallest amount of reflective material of any of the sides of the vehicle. Tyler couldn't see a car was even there, let alone that it was a marked patrol vehicle with two officers inside. Is it unreasonable to believe that a patrol vehicle that was attempting to make itself hard to be seen was successful in doing so? I don't think so. For count 3, the indictment reads that in order to find Tyler guilty of deadly conduct, you have to believe beyond a reasonable doubt that Tyler knowingly discharged his firearm in the direction of a vehicle, as in he knew he was discharging his firearm in the direction of a vehicle, as in he knew that vehicle was there. Ladies and gentlemen, the evidence is overwhelming that Tyler never knew that vehicle was there. In count 3, Tyler would need to know that there are two people in that vehicle that he can't even see. We now have the benefit of having all these facts available to us and all the time needed to look at this case through a more complete lens. It's not enough for the officers to believe that their lives are in danger. You have to believe beyond a reasonable doubt that it was Tyler's conscious objective that he knowingly shot at police officers and he was aware they were there. I'll see the rest of my time, Mr. Nate.
All right, you have 15 minutes.
Thank you, Judge. If you could just give me a second to set up.
Yes, I'll pause your time.
All right, may I proceed, Judge?
Yes.
Thank you. May I please report, counsel?
Drunk and high.
Good morning, ladies and gentlemen. Now you've seen all the facts, all the ingredients, all those conditions that put that perfect storm in motion that I discussed during those statements. That perfect storm that lands Tyler Ashbaugh, innocent of what he's accused of doing, You're possibly facing the rest of his life to lose. You heard that he was drinking heavily. 2 bottles of brandy at work, 300 plus milliliters each. The officer or detective that processed that scene said it was 325 or 375. And so 300 milliliters is roughly 7 shots. So each bottle of that is more than that. 2 24-ounce beers, more beers at Harold's place, and then shots. He couldn't remember how many at the 2 Rivers. He just remembered that he had a double shot before last call. Now, I want to discuss with you the jury instruction, this voluntary intoxication, what it is and what it is not, what it means and what it does not. You can only consider this if you believe all elements have been met beyond a reasonable doubt. That includes that Tyler intentionally and knowingly threatened imminent bodily injury. So this is it. All this instruction is saying is essentially that this is not an excuse. And we've never argued that. Only if you believe that he was guilty of beyond a reasonable doubt of these charges, getting drunk was not an excuse to do that. We've never argued that to you. So what it is not, it's not a substitute for the mental states you still have to believe beyond a reasonable doubt. You still have to believe that he knowingly did this, that he intentionally did this. And intoxication is 100% allowed to be considered as a factor in deciding whether he could have seen the police, their vehicle, or whether other elements of the offense what was met. So you've seen his ID. He has that Class A restriction. What that means is that he cannot operate a vehicle without corrective lenses. And you see that, it states that on the back of his license. You heard from his eye doctor that he has myopia bilateral. What that means is he has trouble seeing things at a distance. And she described in great detail what that means. He has an astigmatism. That makes it even more difficult seeing things at night. And you even saw in the state's own demonstrative exhibit that even with the astigmatism, like the lights are thinner, they're harder to see. He's nearsighted, trouble seeing things at a distance, described that to you. The doctor said no, in response to the state's questioning, he should not be operating a vehicle at night. And so where was the police vehicle? A great distance from that entrance to the church. It was, Officer Hymas testified, it was blacked out. It has a black front. And even in Tyler's statement to Detective Tudor, he's just volunteering this. This isn't any sort of like lie he's concocting. He's just like, you know where you are. I'm sorry, I just can't see very well, but I think I'm downtown at San Antonio Police Headquarters.
All right.
And then we have evidence that he's not wearing his corrective eyewear. So Tyler even testifies to you now, I don't remember. It would be better for him to just, if he was just trying to concoct a lie in court, to say, no, I remember I wasn't wearing my glasses. He says, I don't know, but look what we found that was never collected as evidence. That eyeglass that is exactly like the eyeglasses that Tyler has always worn is sitting there on the floorboard of that Nissan Rogue. And then Tatiana testified that in the jail call she had with Tyler right after he was arrested.
To referring to facts on and evidence, there's no evidence in the jail call.
Well, she testified that this was her statement, Judge.
Ladies and gentlemen, you will remember the evidence as you've heard the evidence.
And she stated, I still have not found your glasses lens. Harold said you got into his car without it.
Except that I think the defense is really the prosecutor. I think we're all being trolled. We're all being punked. I think the prosecutor told this guy right here, listen, I'm going to be your attorney. Don't worry about it. Because all they're talking about is how he's drunk, high, can't see, driving around shooting a gun. I don't really know if I'm defense or not, because I don't really know what's going on.
And I know that his father was, this could have been mine. It might not be. I trust you to look at that for yourself. Is that rectangular or does that appear round? And also, his dad's complaining about the vehicle. He also would have been complaining if he didn't have his glasses for a week, in addition to not having his vehicle. He would have been blowing Tyler up about that. Yeah, and I already discussed that with you. Okay,
What?
so let's look at Tyler's 3 shots, and we don't see the police unit in this video. Well, and once again, I think the audio is a little bit different on the court audio, because it has to go through the computer and all the way here. But look at the exhibit, and you've already heard that in court. Look at it for yourselves when you get back there. And Detective Tudor and Christopher Otero both testified that at the location of the 3rd shot, that vehicle is a little bit protruding from behind that column, and we don't see that police unit yet. So trying to estimate the location of the last shot. This was testified to by Detective Tudor as well. as Christopher Otero, the investigator for the defense. The bumper of the road is still visible behind that last pillar. You can look from the angle of that camera. The police units is not visible. It's behind that building. And the dash, the officers agreed it has branches in that upper corner. And then his first shot appears a lot further back before he's even reached that curb line, which is significantly further. And the police unit is all the way up that hill, blacked out with its lights out. And so you can compare the exhibits that the defense admitted. This one over here is the one on the left is the dash cam of the police unit, and then this one is the one that vetoed. I would argue, if anything, we actually probably parked that a little bit closer. You can see the distance to that building over there on the right. You can see where the lights are. The one in the police unit looks actually like it's a little bit further back than where we parked. So we're not trying to hide anything. We're not trying to make this inaccurate for you. We're just trying to assist you with this investigation. Already discussed that. Okay, and consider Detective Tudor's testimony. He agreed to that location of the first shot and the last shot. Consider that distance. Look at Mr. Otero's video from perspective. You can see that parking lot, how long that parking lot is, how far up it goes, how far up that hill that goes. Consider all that. And then there's very strong evidence that Tyler fired the gun with his right hand. That is going to be critical to this case. He's right-handed. He testified to that. He also told the gunshot residue person that he was right-handed. And there's only gunshot residue detected on his right hand, not on his left hand. That would indicate he's firing the gun with his right hand. And in order to do that, if you're the driver of a vehicle, you can't just reach it out and shoot like this with your left. You have to pull it all the way over your body. You have a lot less distance. If you can reach it out, maybe you could shoot right here into the ground. But if you want to shoot somebody that's in front of you, you have to snake your wrist at a really weird, uncomfortable angle where you have no stability. And Detective Tudor testified from the locations of those shots, yeah, you probably have to shoot through the windshield. And he testified to the dangers of shooting with that weak, unsupported wrist. It could misfire, and anybody that's fired firearms, that could just fly out of your hand if it's over here, way to the right, in that really weird, uncomfortable position. And the first two shots are even further back than what I discussed. Okay, the darkness. There's no moon, there's no stars in any of these videos. The only occasional light is from the flash of lightning behind the cloud cover. That indicates there's also cloud cover, making it darker than it otherwise would have normally been. And so you see, these are their own evidence that comes from the state. And this one, you can see Officer Akumi, the right side of him in this, which is his left side, just kind of blends into the darkness right there. And then the photographs of the stills that we admitted after that police unit rolled down that hill, they retrieved it and they parked it facing it. If you want to watch the rest of that dash video, you'll see when they're looking for shells, they just kind of come in and out of sight. They kind of disappear in the darkness. They're using their flashlights too. If this church is so bright, why do they need to use their flashlights to look for these shells? Why can't they just see it if it's as bright as they want you to believe it is? And these photographs they're taken by a San Antonio police officer, San Antonio police. These are more effective than any argument I could ever make, okay? They say a picture is worth 1,000 words. Same thing. You can't even really tell where this police unit begins and where it ends. This is a high quality, high resolution photograph. That's that unit when it's not even under that tree. That's the unit in the middle of the parking lot. And you've seen that's the alleyway. That's the alleyway where it exits. Okay, and I want to be clear before I discuss this. This is not about whether you believe Officer Hines or Officer Cunha. Nobody in this courtroom is going to call them liars. I have no reason to believe that they're anything other than good people. I have no reason to believe otherwise. But human perceptions can be wrong. They're humans just like everybody else. Officer Hines said it was a Honda Pilot. Why? Because all I saw was the big H. We know it wasn't. Perceptions can be wrong. I'm not saying he's lying. He just misperceived it. He also said the distance was 30 to 40 feet. You've watched where Detective Tudor agreed those shots came from. That is much further back by magnitudes of 30 to 40 feet. And he was sure when he testified, no, we were in the middle of the road until he saw those exhibits. They were on the side. I wasn't parked under that tree. And then once again, when you see it, it is under that tree. And then as soon as I started engaging the vehicle, it had already passed me. And the state brought you the video where you can see the muzzle flash where he fires even just a little bit before it gets level with him. Once again, this is not to say that he came in here and lied. I would completely disagree with the state's counsel that this is about whether you believe Tyler or whether you believe these officers. This is a case about possible misperception combined with those other factors that I told you. A misperception is not a lie. I don't think anybody came in here and lied to try to have Tyler arrested. And as Mr. Salazar stated, think about that call before they arrived. They already have a white SUV in their mind. And so as soon as they see a white SUV, they're on high alert. Okay, there was already a white SUV. They were literally writing our report for right now. There was a carjacking with a deadly weapon. And they testified, they're immediately analyzing that as a threat. Immediately seeing, okay, is this guy going to be a threat? And then what happens is, as soon as they hear a gunshot, I'm under attack. That's what he testified to. I'm under attack, and I have to lay down suppressive fire. So the brain is processing something very intense, very stressful in just a matter of seconds, and it's creating a narrative that makes sense. I wouldn't expect, him to put all the pieces together. That was for the detective to do. You don't have seconds. You have hours. You can take a look at all this. You have the luxury to have all the facts, all the evidence that those officers didn't have in those few seconds. And you heard about Tyler's history of careless but not malicious firearm behavior. The act that he described is not out of character for him. He'd done similar things in the past. The accident inside his room, where he tried to dry fire it and a bullet came out. He hung out with friends who had a similar blasé attitude with firearm safety. And this was one of my regrets, is that I didn't mention this to you in opening statement. I wanted to so that you'd be prepared for it, to know that Tyler lied. I was kicking myself that I didn't tell you guys about it because I wanted you to be prepared for it. This was just another bad decision in a string of horrible decisions. If he's somebody that's dumb and careless enough to shoot out of his window, he's also somebody that's like, we're not talking about sophisticated people in this case when you're talking about like the lay witnesses here. This is somebody who would also just think, oh my gosh, like they think I'm a suspect. What I need to do is just distance myself from this as much.
Nobody remembers your opening statement, except that it was really bad. That's all we remember, is that you called your client a criminal in every way, shape, and form. So why are you telling the jury that your opening statement was really bad? Do you really need to tell them that right now? Do you really need? You could have just said what you had to say.
As possible. And he thinks that's a good idea. But this was an incomplete police investigation. It wasn't an investigation, it was a manhunt. Who was that person? They never did what we did. They never went to the scene and tried to see where could these shots could have come from. They just all they were focused on
3 minutes.
I'm sorry, Judge?
3 minutes.
And so I want you to think about this like if you're a homeowner and this is your yard, it's your responsibility. You have to cut the grass, you have to pull the weeds, you have to do all that. And then if you don't do anything in 3 years, and then we come in as a neighbor and cleaned up, you don't get to complain that we didn't cut the branches the way you wanted them to be done. It was never our job. It was their job from the beginning. The burden is always on the state. Never does it shift to the defense. And so they never did any of this. They never tried to recreate it, measure it, look at what it would have looked like. And I want you to think about why. And it's almost understandable. Once that train is in motion of an officer-involved shooting, you almost have an incentive to not question, to not be the officer that says, hey, could it have maybe have been something else? Could you imagine? That's a dangerous job. You have to know that your brothers and sisters have your back. You have to have their trust. You have to know that they're going to be there for you and they're going to support you. If you have somebody that's always questioning you, then you're not going to trust them. And so he has an incentive to not really go out and try to do the work that we actually did, and to determine, what would this have looked like from the different angles? What would that have done to Detective Tudor's career if he's the guy that says, well, maybe you guys misperceived this. Maybe it wasn't what it looked like. He'd be a stranger in his own department. I don't think he'd have a lot of friends, and that would be a career killer. And once again, that was not our job. That wasn't our burden. Okay. I know that there's going to be a lot of pressure to support the police in this case. That was my greatest fear for this case. But your oath is to decide the case on the facts and the law. There's nothing in that jury charge that's going to say what message you want to send. You don't worry about messages. That's not what you're deciding. You're not deciding who do I like better, anything like that. In the criminal justice system, when we're dealing with years of life as the currency, you can't get it wrong. You just have to have one doubt that's reasonable. And I know I'm kind of running out of time, so I want to, obviously you saw Tyler's Facebook post. He supported police when he had nothing to gain, when it was an unpopular time to do so. And there was no evidence at all that he had any animosity for police officers. The timeline supports his innocence. He left the bar at about 1:55 a.m. and Sergeant Lloyd confirmed that. And it confirms what he told you. I'm not asking, and okay. The state's theory rests on contradictions. So despite drinking, having bad eyesight, and it being in the darkness, he immediately spots officers up a hill in the dark with lights out, when his first chance to spot them would have been while he's driving
10
on the
seconds.
streets. I'm sorry, Judge?
10
10
seconds.
seconds. And so despite that tremendous, vision, he takes 3 terrible shots that have no chance to hit that vehicle, and he doesn't shoot the shot if that was his objective, where he actually could have hit them.
Time.
Can I do one closing remark, Judge?
1 sentence.
Okay. And so this is done during not where he's out roaming about. That's not what any of their location data suggests. So how can he do this act that's so heinous when he's also doing an act which is so mundane and so routine, taking his dad's vehicle back? None of their case makes sense. Tyler, you have plenty of reasonable doubt. We're asking you to find Tyler not guilty on every charge. The same logic applies to counts 1 through 3, that he didn't see them, he wasn't shooting at them, wasn't shooting at a car, wasn't shooting at any people, didn't know they were there. Thank you.
All right. State, I'm going to add an extra 30 seconds. You have 10 minutes and 30 seconds.
Shootout tonight, please fuck. Those are the words that defendant sitting over there texted to his baby mama 30 minutes before he went on a hunt driving around, located this police vehicle, and decided to fire at that vehicle. He saw that vehicle, and that's evidenced in Defendant's Exhibit 139. When you retire to the jury room, look at this. Look at how you can see that entirely black vehicle with no flashing lights on the top, the mount for the lights, no decals. You can see it. He saw it, and he had the perfect opportunity to execute what he's telling Tatiana, that he wanted to be in a shootout. He wanted to engage in gunfire with somebody, and he did. Now, Mr. Garahan already went over the law with you, but I'm going to talk to you about the mental state. Intentional, the defendant's desire. The defendant testified that it was his desire that night to fire that 9mm, because he wasn't going to have his dad's car, and he wasn't going to be able to go to the gun range. And so he gets this bright idea that he was thinking about for more than 30 minutes to go and fire and pop them off in that church parking lot. Okay. The text messages support the intentional. I've just gone over that. And the carport video. That first muzzle flash is going to tell you everything you need to know about this case. It's not that hard, okay? The defendant testified that he holds the wheel from under. It's not that hard to go like this, okay? The sound of the engine revving. You all see that on the state's exhibit. All of those are intentional acts that go to his mental state on that day. You heard the testimony of Officer Jaimes, and we'll go over that, and then the location of the shell casings as well. Knowing. Ladies and gentlemen, that parking lot, you all saw all the light poles in there. You saw the lights on the side of the building by exactly where the officers were parked. He knowingly engaged in his acts, and he knew that that police vehicle was there. He testified that when he would have taken that left turn into the church parking lot, he had a view of the entire parking lot. That is supported by their own exhibits that they entered yesterday. When you retire to the jury room, go look at that and compare it to the evidence that the state presented. And reckless. The defendant admitted while he was on cross-examination that even if things were how he's now concocted, he perceived them to be at the time, he disregarded several risks, even if he was on Santa Gertrudis Street. Testimony is evidence, so we're going to go through the evidence really quick. Sergeant Pearson testified. He processed the scene. He collected those shell casings, and he testified to the lighting conditions. And in that CSI video, you can see those multiple light poles and lights illuminating off of the church side building. Officer Urbanowski makes a scene on Buckmore where he observed the Nissan Rogue and he observed Tyler's name tag and those shell casings in the front driver's side of the Nissan Rogue. Joseph Gonzalez testifies that the defendant's father, that he woke up to heavy police presence at his home that morning of May 22nd, 2022, and he let the police know that the defendant is the only person that had his Nissan Rogue. Detective Robles then conducts the surveillance. He locates the defendant at that Oak Valley apartment complex here in Bear County, where the firearm that matches the shell casings that were located on scene was. And he takes the defendant into custody and transports him downtown. So you heard the testimony from Officer Acuna, and bless his heart, he was only 2 months on the department. And his commitment to our community is so strong that after he was fired upon, he's decided to stay with the department. He testified that he saw the muzzle flash and immediately ducked. What does that tell you? That he observed the muzzle flashing in his direction. Okay, why else would anybody do that? But to threaten the person and place them in fear of imminent bodily injury. We all know what happens if a bullet hits you. Okay, and Officer Hymas testified that he was expecting to take one to the dome that night. That testimony cannot be disregarded. Also, guess who else has vision issues? Officer Acuna, but he has the wherewithal to say, hey, I am not going to add any more danger to this situation. I am not going to fire my weapon. Something that defendant should have done that night. Officer Hymas and Officer Acuna's perception is one that you can trust because they were sober. They were on duty. They were doing their job and protecting our community. And their versions are corroborated by the video evidence and all of the other evidence that we have presented to you all in this case. Now, how can you tell if somebody is a police officer? We talked about this in jury selection. The badge, the car, the marked patrol car, the decals that are reflective, okay? And then they want to talk about astigmatism. You heard their witness testify that for your astigmatism to be activated, the light has to flash in your eye, okay? Look at the state's exhibit and what that would look like to an eye. Now, Harold, this is very important. The defendant and Harold did not have an opportunity to corroborate their stories before they went down to headquarters. They've since had 3 years to do so. And so what is important? Harold never tells Detective Martinez about Two Rivers Tavern. He never says that he was following the defendant down O'Connor Road. But what he does say is that he was blindsided by this entire event and that he didn't believe Tyler at the time. Tatiana testified that the defendant asked her to lie about his whereabouts during the time of this offense. All of that goes to his mental state at the time. He knows what he did. And now you do too. Then he gives his interview to Detective Tudor. He lies, and more lies. He says he went to the bar before dropping off the car. He was never shot at all. He dropped the vehicle off and it was fine. There was no damage to the vehicle. He's never even shot this 9mm. He has no clue about shell casings or why they would be in the vehicle.
3
And
minutes.
the ballistics will show that he's innocent. Okay, and he says something very interesting, because he's trying to sell his story. Let me tell you something about honesty. You can't get caught for it. Well, newsflash, you did. He did. He got caught for being dishonest. And that was his story. And he was sticking to it. And then here comes all the scientific evidence. The DNA that Robert Saylors testified to, the GSR, by the way, the shirt that he's wearing in that police interview came back with 10 of 10 particles, okay? And then the one on the right, which indicates that he was firing and he's admitted to. And then Holly Warden, that the shell case
But he said that he shot the gun. so what the heck?
things do match up. And so then come the text messages. Shootout tonight, please fuck. I'm going to jail. Bro, got into some shit. Be up at the store. And regarding the shootout tonight, he sure has an explanation for that now. Oh, he was trying to manipulate Tatiana. But then when I confront him about it, Tatiana was the one that was trying to get in contact with him. It was not the other way around that night. And then when he's talking to Detective Tudor about that, he goes, oh, it's because I heard a shooting. Nothing that came out of that defendant's mouth can you believe, okay? Because it's all lies. And then after viewing all of this evidence, he concocts this story, okay? He's transforming it because nobody's gonna believe that I didn't fire the weapon when I have GSR on me, when the shell casings match my gun. Nobody's gonna believe that. So then I'm just gonna change it, okay, to something that can maybe be believable, despite overwhelming evidence that the state is bringing you. You are the exclusive judges of the credibility of the witnesses. And he has the biggest incentive to get up there and tell you a story that's not based in fact, reason, or supported by the evidence, okay? He wants you to believe he's telling the truth now after 3 years. He remembers only the facts that are beneficial to his defense. I can't remember if I was wearing my eyeglasses. Oh, but I know I didn't see that car. And I know that I didn't know that they were police officers. All things that are in the indictment that he is seeking to escape. His rendition is not supported by the evidence at all.
20 seconds.
It's easy to Monday morning quarterback when you know that you are going to face a jury of your peers. I want you to imagine what our community would be like. What our community would be like if this is how police officers are repaid when they're finishing up a report for an aggravated robbery and this defendant gets to walk scot-free.
Objection, improper
Wow.
argument.
It's a plea to law enforcement.
I think it's an improper plea to law enforcement. Objection,
All right,
improper.
that'll be overruled. All right,
Is that the community that you want to live in?
time.
Find him guilty.
Do not do that during a closing, sir.
All right,
Unless you
ladies
are
and gentlemen,
hungry,
Deputy
man.
Laura will take you to the back to select your foreperson and begin your deliberations. Everyone, please rise for the jurors. All right, everyone, please be seated.
Okay, now the problem.
And everyone, please confirm.
I don't know. I don't think the verdict is today, but I don't know when the verdict is. Hold on. I'm pretty sure it's the next day. So let's just fast forward. Josh isn't here to tell me. I was sort of hoping Josh would tell me. But he's not here. Should I call him and wake him up? I should call him and wake him up, shouldn't I? Verdict was on Friday, but that doesn't help. Is this Friday? Don't worry, guys. We'll find it. We're professionals. No, I know there was a verdict because we were talking about it in American Courts. The real famous YouTuber I know, American Courts. Like, I could call him right now. That's how famous I am. I can call American Courts. Although Emily would probably kill me. Oh, I see something, guys. It's
All right,
muted.
it's the court's
Okay.
understanding that a verdict has been reached. There are not to be any outbursts in this courtroom. Does everybody understand?
Oh, well, we're going to outburst over here, Judge. What you going to do about it? Nothing. Oh, nice bag. Did you see that? Am I in the wrong video, Fozzie? I fast forwarded to here. That's not where the defendant sits when they read it. It's okay. We have 45 minutes to burn yet. So we're just going to sit and watch this part.
All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is that verdict unanimous?
I like this bag
And did everyone sign the verdict form?
and the flowers.
All right, if you'll hand the verdict form to the deputy, please.
KS knows too. They don't know stinking Josh.
All right, if the defendant will please rise. The verdict form states, count one. We, the jury, find the defendant Tyler Ashfall guilty of the offense of aggravated assault against a public servant as charged in count one of the indictment. Count two. We, the jury, find the defendant Tyler Ashfall guilty of the offense of aggravated assault against a public servant as charged in count two of the indictment. Count 3A. We, the jury, find the defendant Tyler Ashfall guilty of the offense of deadly conduct as charged in count 3, paragraph A of the indictment. Count 3, paragraph B, verdict form. We, the jury, find the defendant Tyler Ashfall guilty of the offense of deadly conduct as charged in count 3, paragraph B of the indictment. The jury forms appear to be in proper order, and it appears to be signed by all the jurors. Which anyone wish to have the jurors polled? All right, ladies and gentlemen, I'm going to point to you and ask you if this is your verdict in each of the counts, and if you sign the verdict in each of the counts. If the answer is yes.
I feel bad for him. I feel really bad for him right now. I don't know if he shot at that police car on purpose. I don't know. He was drunk. He was high. It could be either that he put his gun out the window just to fire it, which is just stupid. Or he shot at the police car. I don't know. I'm not even leaning one way or another. I don't know if he did or didn't. Part of me thinks he did. Part of me thinks he didn't. But I feel really bad for him. And I don't want to get to the sentences because I don't want to see what's about to happen, but don't worry. We're going to fast forward to 9 minutes and 50 seconds in a minute and get there.
I need everyone to respond yes. Does everyone understand? We're going to start on the end on the front row. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? We'll start on the back row. Is this your verdict? 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 All right. So ladies and gentlemen, what's going to happen now? It's almost 5 o'clock. We can start the second phase of the trial tomorrow at 9 a.m. or, all right, I will have you all discuss it. All right. So if everyone will please rise for the jurors.
Thank you, Kelly. Kelly, thank you. Let's not watch the sentencing. Kelly just said he'd get probation. So we'll just go with that. And I won't feel so bad for him. I feel so bad. I usually don't feel that bad for the people who are found guilty. I just don't. Okay, you are right. Just shooting your gun for no reason. Stupid. Just so stupid. Okay. All right. All right. We're going to go to the 17-minute video like we're told. And we're going to go to 9:50 like we're told. 9:47 because I don't listen.
All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict as to punishment. Is that correct? And is that verdict unanimous? All right, if you'll give the form to the deputy, please. Thank you.
Every time a man says, "Get ready" to me, I'm disappointed.
All right, the verdict form appears to be in proper order and reads as follows. Count one. We find the allegations contained in the repeat offender enhancement allegation paragraph of the indictment true. We therefore assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 15 years. There is no fine. Count two. The verdict reads as follows. We find the allegations contained in the repeat offender enhancement allegation paragraph of the indictment true. We therefore assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 15 years. No fine. Count three. It reads as follows. We find the allegations contained in the repeat offender enhancement allegation paragraph of the indictment true. We therefore assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 2 years with no fine. Is there anyone who wishes to have the jury polled?
Yes, Your Honor.
All right, ladies and gentlemen, I'm going to ask you if this is your verdicts in count one, count two, and count three. If that is your verdict, then I need you to respond yes. Does everyone understand? All right, and I'll start here. Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Is this your verdict? All right, ladies and gentlemen, I'm going to have
Consecutive? What did they say? She didn't.
you go back to the jury room and I'll meet you back there shortly. Everyone, please rise for the jurors.
I just put out a video last night. I think it was last night. I don't know. He was, a 9-time felon. And this was his he had 9 felonies. This one was his 4th burglary felony. And he got 8 years. And that's not even true time. Like, he got 8 years, but he's only gonna have to serve, 3 years or whatever. Hi, Walter. This guy shoots a gun out of his window and he's getting 15 years. Now, they could put that too concurrent. I don't know. We haven't decided yet. What? That doesn't make any sense. It was a different state, Colorado versus Texas. But we've seen people in Texas do much worse or much less. I don't understand. Is it because the jury decided? Is that why it's so far? Because usually the judge decides, but this one, the jury decided the punishment. Okay, he shot at police. That does make a huge difference. That does. It's even to me. Oh God, I really, really wish Judge Fleischer was streaming again. I really do. I think there was a new law that put out, and I listen, I could be wrong. I was just listening to Judge Eric. I think there was a new law put out that any undocumented get no bond. You can't have a bond hearing for anybody, any undocumented that are arrested for anything. You can't have a bond hearing at all for them. So, you know how Judge Fleischer was like, if you get arrested, you're going to sit there until ICE gets you. No, everybody sits there until ICE gets them now. Every single person. And I'm wondering what that's going to do to these courts, these jails now. I mean, that's everybody. I mean, that was what? I'm just going to guess. That was 65% of his entire docket every single day. So I think this just passed. And I really wish Judge Fleischer was streaming again because I want to know what's going to go down. Maybe I'll get Juanita. Her audio is so bad, but maybe I'll get Juanita today. Oh, I wish her audio was better so that we can see what this new law. I don't know. She starts in maybe 4 or 5 hours. She starts way later than Judge Fleischer did. Yeah, where in the world are these millions and millions and millions of people going to go? I'll take 1 prisoner if you take 3 cats. I mean, what? I don't know. All right, let's get back to this though. Let's focus. Sorry, I went off the rails.
All right. Mr. Ashbaugh, the court will follow the sentencing as required by law that the jury has imposed. In counts 1, counts 2, you'll be sentenced to 15 years in the prison. In each count, there's an affirmative finding of deadly weapon. There's to be $0 fine.
And Judge, I'm sorry to but on count 3, we're going to just have to reurge our objection to the sentence on that because deadly conduct with a firearm is a lesser included of aggravated assault on a public servant and it would violate his double jeopardy rights.
All right. And state your response.
How many do you want? I'll drive them to you. How many?
All right. And then in count 3, the court will sentence you to 2 years in the prison. Just one moment.
Six sounds like a good number. Eileen, do you want 6?
There's a 2-year sentence in count 3. There is no fine. Does anyone want to address any other issues with regards to sentencing?
You just asked, you heard all our arguments at sentencing. Mr. Ashbaugh has not abused his court's discretion at all when you give it any leeway on his GPS. He's taken every little liberty that you've given him. He hasn't used it in any way. You've heard from his witnesses that he's really matured a lot in these 3 years. And just asked people to say, did you run them together, Your Honor, and not back?
All right, state. All right. Then the cases were run concurrently. Is there anything else with regards to sentencing?
None from the defense.
All right. Could someone have the clerk to bring me out the docket sheet? Because I don't see a docket sheet for this case. All right, Mr. Ashbaugh, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? All right, because this is not a plea bargain agreement, you do have the right to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Excuse me, sir. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right. Is there anything else before the court closes? What I can tell you, Mr. Ashbaugh, is I am not in charge of security for the courtroom. I firmly believe that everyone has their roles. And so if the deputies say the answer is no, then the answer is no, because they're in charge of security. And I don't want to violate or interfere with their ability to do their duties. All right. Is there anything else from either side?
No, Your Honor.
All right, then the record is closed. Yes. Sure.
Seven it is. I will drive 7 to you right now if you're serious. I will just drive them to you. Let's finish out with Judge Boyd. We still have a few more minutes. We'll start here.
And are you all ready to proceed on the motions?
Yes, Your Honor.
You better not have driven to them. I'm telling the judge. I can text him.
All right, the court is calling 2024 CR 007423, 2024 CR 007444, 2024 CR 6757, State versus Noah Javier Gonzalez. Can I have parties announced?
Deputy Clerk for the state of Texas, Your Honor.
Humberto Saldaña for Noah Javier Gonzalez.
And are you Noah Javier Gonzalez? And each of these cause numbers, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
And cause number 2024 CR 007423. Are you the same Noah Javier Gonzalez who's placed on deferred adjudication for theft of property, $2,500 but less than $30,000 on September 23rd, 2024 for a period of 4 years?
Yes, ma'am.
Are you the same Noah Javier Gonzalez who's placed on deferred adjudication in 2024 CR 007444 for the offense of unauthorized use of a vehicle on September 23rd, 2024 for a period of 4 years?
Yes, ma'am.
And are you the same Noah Javier Gonzalez who's placed on deferred adjudication in 2024 CR 6757 for the offense of theft of property, $2,500 but less than $30,000 on July 16, 2024 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state, are you proceeding on the same allegation in each motion?
Yes, Your Honor.
All right, state, you may proceed.
Violation of condition number 4, in Bexar County, Texas, the defendant, Noah Javier Gonzalez, did then and there fail to report to the supervision officer as directed for the month of December 2024 in violation of condition number 4.
And each cause number, how do you plead to that, true or not true?
True. The state will waive and abandon the remaining violations in each cause number, Your Honor.
Any objection?
No objection.
In each cause number, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and each cause number, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4 in each cause number?
Yes, ma'am.
In each cause number, the court will find violation of condition number 4 true. Is there a proposed agreement?
There is, the state may believe that defense may want to speak to a condition, but there is an agreed recommendation, Your Honor.
And what is the recommendation?
That is to deny the state's motion to continue probationer on deferred in all 3 cases, but to amend conditions to now include safe PF in each 3 causes.
And Your Honor, we wanted to address that if we could, put on some, I wanted to call my client.
All right, so here's the question. Was he in a coma? Because we haven't seen him since December. So is there a reason why nobody's seen him since December? Because that's December, January, February, March, April, May, June, and now we see you. That's 7 months later. So is there going to be information that he was in the hospital or being held hostage?
So, remember that judge in Colorado? Oh gosh, I don't remember her name. And okay, Anthony did post that in Discord, guys. My son did actually post that in Discord. I went upstairs, his keyboard stopped working, so he came over to steal mine and saw my Discord and was like, hey, should I just do a stream about politics and no court at all, just politics? Listen, I know there's some young ones that watch these a little bit, maybe don't have kids. Do not have kids. Whatever you do not have kids. Just skip right to the grandchildren. I don't know how. I don't know how you can do that, but don't have children. It's all right. He's gone now. I got rid of him. I'm done with him. Okay. I was saying something before I got. Oh yeah. Remember that judge in Colorado? When you miss court and she gets you back because they picked you up on a warrant, she holds you for the amount of time that you missed, that you did not show up for court. So if it's 3 months, if you were absconded for 3 months, you're staying in jail for 3 months, then she'll set your bond reasonably. 6 months, 6 months in jail, then she'll set your bond reasonably. It's crazy. We saw her do it. We saw her. Let's see what he gets. See what Boyd does.
In some kind of way, he couldn't make it.
Judge, but I do think that there's some mitigation that.
All right, let me hear the mitigation. I'll keep an open mind, but let me hear mitigation. Who are you calling?
Mr. Garcia first, and then his mother is here also.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Noah Javier Gonzalez.
All right, you may proceed.
You've been incarcerated in Bexar County how long, sir?
As long as I was in Bexar County for like 3 months.
And how long? My question to you is, when were you incarcerated on this MTU?
This NCR on June 14th.
June 14th, okay. prior to June 14th, what was your status as far as residing with your mother?
I ended up having to go live with my father in Marble Falls, which was all communicated through my probation officer. She knew that I went out there.
So the probation officer gave her blessing for you to,
I gave her proof of address and everything, and proof of job. I was working in Marble Falls.
do me a favor, wait till I finish my question before you answer, because she's taking down everything you say,
Yes, sir.
and that way we can have a clean record. So when did you go move with your dad to Marble Falls?
Met 2 months after my release.
And when was your release?
I was released in November. I want to say November, between November 15th and November 23rd.
Of 2024.
Yes, sir.
So how many times had you reported to the people in Marble Falls?
I didn't report to nobody in Marble Falls. I was coming back every week to report down here in the Windcrest office.
Okay. When you say every week, when can you give the court the dates of when you came to report to Windcrest?
It was once a week. I don't know the exact dates, but it was once a week. I came back every Thursday, every Friday. We would come back, me and my dad, and I would report Friday.
Okay. And
So I'm sorry. So is he saying that he actually reported December? Is that the testimony I'm hearing?
that's,
I did report. I took a urinalysis, and
No. Here's my thing. I don't understand the plea of true if he's telling the court that he reported December 2024. If he's saying he was reporting, then sounds like we need to have the probation officer zoom in, if nobody has any objection, to tell the court that he was actually reporting, because he's just pled true to not reporting for December 2024. And what I can tell you, usually when it says you haven't reported since December 2024, that means that probation has not seen you since December 2024.
yes, ma'am. But I definitely did report. I was going once a week.
Then
Judge, I don't mean to,
no.
but I think that the allegation says he didn't report in December 2024, not,
Yeah.
he didn't report then, and January, February, March, April, May. I don't believe it says that, but I could be wrong.
No, it says in Bexar County, Texas, the defendant Noah Javier Gonzalez did then and there fail to report to the supervision officer as directed for the month of December 2024 in violation of condition number 4. So my understanding about rules of, conditions of probation, we can go off the record. They will give you a specific date to report in December. You don't get to choose which date you report from. They'll tell you, we want you here on December 14th, whatever they'll tell you. Once you report, they mark it off that you report. And then they'll tell you the next month what day they want you to report. And usually it's the same day unless something happens and it falls on the weekend. So what I'm hearing from your client is he's telling the court he reported December. Is that what I'm hearing? Do we need to have the probation officer zoom in? Because if he reported, then I don't know why we have this motion to revoke, but they're saying they haven't seen him since December 2024. And if he's telling me he's reported, then maybe he shouldn't be here.
Judge, I hate to go back to this, but I think as to December, you didn't report. Is that what you're saying? But all the other months that you reported, is that what you're telling
I
the
don't
court?
remember reporting in December, but I know for a fact that I reported multiple times throughout those other months that I was on
All right, Ms.
probation.
Abrams, this needs to be cleared up. Is it possible? Does anyone object to the probation officer zooming in?
No,
The state does not.
defense does not.
All righty. And Ms. Abrams, he's saying he reported here in Bexar County. So if y'all have a seat, the probation officer will zoom in and we'll see what's going on.
Judge, from what you read, it said just December. In the month of December, it said. That's what you
Alrighty.
read out loud. So I'm going to bump it forward to him.
Who's here on Shannon
There
Patton?
he is. No, Shannon. Stay away, Shannon.
it's-
Let the
We
music-
are ready.
Okay.
You won't get away.
Oh, Mr. Sawyer, so your client will need to sign the reset form. All right, thank you. All right, we are back on the record in 2024, CR 007423, 2024 CR 007444, and 2024 CR 6757, State versus Noah Javier Gonzalez. Could I have all parties re-announced, please?
Duffy Pitlock for the state of Texas, Your Honor.
Humberto Saldaña for Noah Javier Gonzalez.
All right, so where we are is your client has testified that he actually reported in December 2024. So is there any objection? Because we can just get to the point with the probation officer, either he reported or he did not. Any objection
No,
to
that's
going out
not
of
what he
order and
said.
just calling the,
That's not what he said, and that's not what you said, Judge. He said he doesn't remember reporting in December, but he has reported after that since then.
probation officer?
No objection from the state, Your Honor.
Judge Mayor,
Yes.
What I had stated was, I'm not sure if I reported in December, but I'm sure that I reported multiple times.
Oh, we're gonna find out what's going on from probation. Any objections?
no objection.
All right, and the probation officer is by Zoom. Any objections to the officer being by Zoom?
None from the state.
None from defense.
All right. Officer Neal, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name and occupation for the record.
Kiana Neal, supervision officer.
All right, does anyone want to question her about the allegations in the motion?
The state may begin. Officer Neal, the state read a violation. It was number 4, that in Bear County, defendant failed to report to the supervision officer as directed for the month of December 2024 in violation of condition number 4. Defendant did plead true, but then there was discussion as to whether defendant did or did not report in December. So the state's one question would be, according to your records, did defendant report for the month of December as directed according to the conditions of his probation?
No, he did not. I did have collateral contact with his mother, but not him.
Now, does collateral contact count as reporting under the terms of the contract?
No.
And would that have been described to defendant? Like, did he know collateral would not work?
I think at that point he had just got out of custody. He was
And
in Bear County for a new offense prior to that.
And
So
when
I hadn't met him just yet.
you had not met.
No, sir.
Now, when probationer is released, does someone go over the terms when he's released, or that would be you and that did not happen?
Correct. We were waiting for that appointment, which he didn't show up to.
Now, is not showing up to the appointment a violation?
Correct. It's failing to report for that month.
Then, Your Honor, the state does not believe we have any further questions.
Any questions?
Were you aware that Mr. Gonzalez had tried to transfer his probation to another county?
Yes. We did talk about that, and he said he was no longer looking to transfer his probation.
And are you at the Windcrest office, is that right?
Correct.
Okay. And how many times did you see Mr. Gonzalez during the time that he was on probation?
4 or 5 times.
4 or 5 times. So that would have been, is it once a month reporting,
Well, he's on weekly.
weekly? Okay. So do you know what months that he reported to you if he was weekly?
Okay, give me a second. All right, can you give me a second so I can get that information for you?
Sure.
All right. All right, he did come in February. Of 2025.
What about March?
Yes, he came in March.
How about April?
Hold on, I'm scrolling through to make sure.
Julian can't. Right, Michael? Julian can't put his cup down.
I do not see where he reported in April.
Okay. Did he show up in May?
No,
And he's been in custody, if you know, since June the 14th, is that right, of this year?
correct.
So, April and May, he did not, and then he was arrested in June. Is that your understanding?
Yes,
So he's been in custody roughly about a month and a half.
correct. And he did have a couple issues with charging his device, his GPS device as well.
Okay. So was that mainly due to monies?
So charging it has nothing to do with money.
Okay. So what was did he have a solid residence at the time that he was on reporting?
So we did talk about how he did have some family issues.
And were those family issues regarding his mother?
Correct.
And in essence, his mother was not allowing him to stay at her house, is that right?
Yes.
Okay. So when he would go to Marble Falls, is it your understanding that he would spend the night in Marble Falls?
We did talk about it a couple times. I tried to get him to give me proof of residency there.
But you did understand that he was contending he was living in Marble Falls and then commuting back to report to you.
I don't know who this person is right here behind his elbow, but the last person who sat in that chair, buddy, had a bad freaking day. You might want to find a different seat.
I'm sorry, you breaking up.
You did understand that he was living in Marble Falls. That's what he was saying. And he was traveling back to report to you.
So yes, I was gonna get him to provide me proof of residency so we could get it to judge.
I love how you think.
Okay.
I love it.
And the allegations or the allegation of not reporting, it's not like you're saying that you haven't seen him since December, right?
No, so I did see him periodically through the time that he's been on.
And do you know how old Mr. Gonzalez is?
He's 19.
19. Okay. And so you would say that's a pretty young man? Would you agree with me on that he's a young man?
Yes, he's grown.
Okay. And Mr. Gonzalez took some UAs for you as well, did he not?
He did.
And they were all negative?
Correct.
Okay. Did he ever give you any concern that he was using drugs or alcohol?
I received some anonymous phone calls that he made.
The hell do you
Have.
mean for men? Long
But
hair
that
is
never
love.
was borne out in the test, right?
No.
I'll pass the witness.
Any further questions?
Nothing.
All right. So and this is not a question for you, but it's a question for attorneys. I didn't give anyone permission to reside in Marble Falls. That's one of my questions. And my other question, if his mom wouldn't allow him to live with her, then why is she in court today? What is the purpose?
Judge, I think she wanted to explain that. I think she's here to support him. She may not agree with everything Mr. Gonzalez is doing, but she's here to explain that she loves her son and she hopes that one day he'll get it right and.
All right.
All
All right, that'll be noted. Your mother loves you. She hopes one day that you can get your life together. Do you understand? and you haven't been doing things that you need to do in order to get your life together. Because I had you on a curfew. I had you on GPS. There were no issue with fees because the fees were waived and he's supposed to be on curfew, but he's just doing what he wants to do. Oh, let me go to Marble Falls. And I know I specifically told you if there's an issue, all you had to do was contact probation. You're here for 3 felonies. And now it appears that someone wants to do this. He's only 19. He tried to report, didn't do it well. He's on probation for 3 felonies. And, you know, somebody wants to do the Puss in Boots eyes at me as though, you know, I'm 19, woe is me. I don't understand.
No, Judge, I don't think that that's what really is trying to be conveyed. I think what it is that Mr. Gonzalez had not been in this position before. And I think that out of necessity, because he couldn't live with his mom, he had to go live with his dad and he doesn't reside in Bear
And
County.
he didn't pick up the phone and he didn't call probation or come back to this court on all the trips that he would come and come back to this court and say, Judge, I have an issue. I can't live with my mom.
If I may,
Yes.
I did tell her about my situation when I went and for going to Marble Falls, and I did ask like a request for some type of compliance there with you to go over it, but I never got a compliance one.
Nobody came to me with a compliance hearing. So, State, what are you asking for?
We originally asked for the 3 motions to be denied and to continue probationer on deferred, but to amend to include SafeP for a more structured environment.
All right. So here's what's going to end up happening.
She's not
One of
going to
2
give
things.
you that. Nope.
He's
nope.
not getting out of custody today. How he wants to spend that depends on him. 1, I can revoke you. And I understand you have issues. You're 19. You say your mom doesn't want you living with her anymore. So I can send him to the state jail facility and I'll send him to the state jail facility for 200 days. Or he can await transfer to inpatient drug treatment. Those are his only 2 choices.
I'll take the first choice.
What, you want to just do your time? All right, so let me explain. I'm going to give you a chance to talk to your attorney about that because let me just tell you what that's going to be. That's going to be a felony conviction. Have you ever had a felony conviction before? We can go off the record. There are consequences to felony convictions. And let me just tell you, what you're charged with, the theft cases, those are what are called crimes of moral turpitude. If you were to be charged with murder and get convicted of a murder, that's not necessarily a crime of moral turpitude, but theft is. And that is a bigger stain on your record than having gone to prison for aggravated assault with a deadly weapon against somebody who wasn't a female, because charges against females are crimes of moral turpitude, right?
Yes.
And with crimes of moral turpitude, that means that anything that has to do with license that you're trying to do for yourself, it's going to be extremely difficult, if not impossible, for you to get that license. It's going to be slim to none. And then there are issues with your voting rights being taken away. And there's your issue with being allowed to serve on a jury, because those are crimes of moral turpitude and because they are felonies. So you may want to discuss that with your attorney. And I can tell you also, within a felony conviction and crimes of moral turpitude, if you're thinking of getting some type of school aid to go to college, or you have a child and something happens and your child needs help, or you need help through WIC or SNAP or whatever it is, you're not getting it because of this. Do you understand? So I'll let you discuss it with your attorney.
Kato is so cute, like a puppy. I just want.
Thank
I
you
want
so
a little
much for coming
Kato in
in.
my room.
Officer
You're
Neal.
welcome. You're welcome.
Who's here on Matthew Longoria?
Hi.
I'm sorry, yes, Ms. Neal?
Oh, I can log out?
Yes.
Okay, thank you.
Longoria, it will be Santos, and then it will be Richard Cantu, and then it will be Ricky Thatcher. That's the order in which I've received documents. Court is calling 2024 CR 008934. State.
Guys, we don't get it. We don't get. Come on, Judge. Unless I missed it. Hold on. I don't think I missed it. That's it. All right, we know what happened. He's going into inpatient. He's going into inpatient so he doesn't get a felony on his record of moral turpitude. Oh, but she's in a mood today, isn't she? Whew. I wonder why. I wonder why she's in such a mood. Okay. This should already pop you over to OJ. Thank you so much for watching this whole trial with me. Now we get back to regular clips tomorrow if I can find content. It's so much easier when I do a trial. All right. I'm going to give you new judges tomorrow. Old judges, but judges exclusive to only this channel that you cannot get on other channels. When are my hours? What? I don't understand the question. When are my hours? 24/7. Those are my hours. 24/7. Except maybe 4:30. My hours are apparently today my hours are everything except for 4:30. It happens, you know? It happens. Thank you so much for coming out, guys. I'm on every morning around 4:30ish, and then again at around whatever time 7ish for OJ, 6:30ish for OJ, and then trying to do 3 videos every day, one at 11, one at 7, one at 11, all Eastern Standard Time. Try to get some shorts out in between if I can. I'm not succeeding, but you know what? I'm doing the best I can. That's when I'm on. Around 4:30, Kelly. Somewhere near the 4:30 mark. Some days it is 4:30. But that's when I'm on. But it says so in all of my descriptions and everything. Doesn't hurt. It hasn't been hurting. Nope, it has not. You should see what's going on in my channel right now. It's pretty nice. All right. You are being nice. You are. Hey, Tona, shut up. $1 a minute. I'll do a marathon. $1 a minute. $1 a minute. I did like a free marathon. Not totally free. Not totally free. A few weeks ago. But it was way different than my first marathon. Give or take 40 minutes or so. Most days it's not 40 minutes. Most days it's littler. Just, 15 minutes. It's somewhere between 4:30 and 4:45. Snoopy. How's your neck? I know it sucks. I know you're still in pain. You don't even have to answer. I know. I'm sorry. I wish I could fix it for you. I know you have another surgery coming up. You and Kelly should talk. It sucks. All right. OJ, I need to get to OJ because people are waiting. John the Beagle Dad is probably having a fit right now. No, not today because I was awake and I was ready for my stream. I was awake and I was getting ready for my stream. I was just puttering around doing stuff. And then I'm like, okay, I'm just going to close my eyes for 1 minute. And I did. I closed my eyes. And then I wake them back up. It's fine, though. I eventually woke up. 2 minutes. All right. All right. I'm going to put this in the bank. When we get to 4 hours, I will do a marathon. $1 a minute. So this 2 minutes, there's already in the bank. When we get to 4 hours, because what's the use of doing a marathon if it's less than 4 hours? I'll do the marathon. I'm going to put this in Discord under that. I think I already have something Hold on, I do think I already have something. Hold on. Marathon stream. Oh, man. Here is where I'm going to start keeping tabs. That's my Discord link for just the marathon stream. Once we get to 4 hours, two minutes. And Jude, you're in. You're locked in for 2 minutes. The first 2 minutes. And just so you know, so my very first super chat from YouTube was from Treasure X. It was for $9.99. YouTube gave me $4.90 from that, which was great, which made me happy. It did. I'm not complaining. I'm just not complaining. I just hope you realize that I'm not complaining. But these guys give me almost all of it. If YouTube is, oh, let me try that again. We need, there. If YouTube is the best way for you to do it, that's fine. If this is an easier way to do it, that would be great. That would be great, because I get more of it that way, and you know, Treasure X is awesome, so awesome. Been with me from like way, way, way back when. Mike Baker, haven't seen Mike Baker in so long. Oh well, they'll be back. They'll come back someday and say hi. Yeah, they are. And it's fine. It's fine. It's absolutely fine. I mean, you know, that I'm not going to complain. I'm just saying. All right. I got to get to OJ. I have to. Thank you so much for coming out, guys. I really appreciate it. I really, really do. And I shall see you again really soon. Bye.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dream tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. these lies.